Hello and welcome. My name is Jeremy Glover. It's a pleasure to welcome you to our first Fenwick Elliott webinar for 2023. Today we're focusing on adjudication, and more specifically the King's College London and Adjudication Society study on adjudication, which came out at the end of last year and which itself builds on the studies previously carried out by Janie Milligan. The findings make interesting and indeed striking reading, and I'm happy to say that our speakers today, Fenwick Elliott partner Claire King and Lynne McCafferty KC from Four Pump Court, are the perfect people to guide us through the findings, as they both served on the steering committee for the study. They're therefore ideally placed to analyse the report's suggestions for improvement and how those could be actually achieved and implemented. Claire, as you probably know, has been at Fenwick Elliott for some 14 years now. She currently sits on the Adjudication Society Committee. She also edits, which actually means drafts, the Fenwick Elliott Insight, one of our regular newsletters, and a companion issue of Insight is coming out shortly to complement today's webinar. Described in directories as simply one of the best silks around, Lynne regularly appears in the TCC, and if you come across her in the TCC, you should be aware that her preparation and cross-examination has been described as meticulous, fierce, and incisive. She is also appointed to TechBar's panel of accredited adjudicators, so like Claire, has a wealth of practical adjudication experience built up over the years. So before I hand over to them, just a reminder that you're all on mute. Please do send in any questions, and you should be able to find the slides on our website later in the week. A link will be put in the chat during the webinar. But Claire, over to you.
Thank you very much, Jeremy. As Jeremy said, we are going to review the key findings of the 2022 Adjudication Society report and King's College London report on adjudication during this webinar. As we do so, we're going to discuss the implications of those findings. But going through, we're also going to ask what do they suggest for the future in terms of reform or good practice, and focus on that particularly in the last part of the webinar. So with that, I'm going to hand over first to Lynne.
Thanks very much, Claire. Thank you, and welcome to everybody on the webinar. It's a pleasure to join you all. As Claire and Jeremy have said, this survey is a joint effort by a number of people, but it's very much been led by a team at the King's College Centre for Construction Law and Dispute Resolution, Professor Renato Nazzini and Alexander Kalis. So it has a great deal of academic rigour behind it. And both Claire and I, as we mentioned, were on the steering committee for that. It does build on previous surveys that have been done by others, including, as Jeremy mentioned, Janie Milligan at Strathclyde University. But that survey was, I understand, focused on getting responses from ANBs, from adjudicator nominating bodies, whereas the survey that we're looking at today has also extensively surveyed individuals who are practitioners within the industry, some adjudicators, some lawyers, claims consultants, parties. So it does have a very wide spread of responses and experience reflected in its findings. The aim is for this to be an annual survey, which will enable the Centre for Construction Law and all of those who are interested in adjudication to monitor how trends are changing and to get a sense of how successful adjudication is, what changes might need to be made to it, and just really to give some further data and information to help with understanding its place within the construction industry dispute resolution options. We've set out the foreword that was provided by Lord Justice Coulson to the survey, and I think that reflects the fact that this is really the first time that we have had such a comprehensive survey of construction adjudication. And it's, I think, very helpful given the importance of adjudication to the industry. The findings and the survey results within the survey really bear out the fact that adjudication is extremely widely used within the industry, and also that generally people using adjudication are largely accepting the decisions provided by adjudicators, as we'll come on to see later in the talk. Now, I'm going to move on next to just very quickly set out some of the methodology so that those who are not yet familiar with the survey report can understand what it was actually surveying. There were 2 different questionnaires sent out. One was sent out to the ANBs and one was sent out to individual participants. Of those who responded, really the main ANBs, the biggest and the most commonly used ANBs responded, and we've listed in the slides the 10 who responded. And we had 257 individual participants respond to the second questionnaire, which we felt gave a very good cross-section of responses and a good set of statistics to use and to draw conclusions from. What's interesting is that many of those responding are based in the London and South East region, 53% of them. But that may actually be what one would expect given the concentration of many of the large law firms, construction companies and so on within that region. The results also show that those responding come from quite a wide range of different seniority, and this particular slide shows that it reflects the experience of people who are doing a small number of adjudications and also those who have had the fortune or the misfortune, depending how you view it, to do more than 500 adjudications. So it really has quite a wide spread of participation, which I think is helpful. It's not just the battle-hardened people responding, it's also those who are maybe dabbling a little bit more in adjudication. It's not necessarily the main focus of their practice, which I think does give a good spread of experience and response. Turning then on to some of the statistics that were provided by the ANBs, that showed that the largest ANB in terms of the number of adjudication referrals is the IICS, which is perhaps as one would expect given the prevalence of payment disputes, final account disputes and so on within adjudication. It also shows a large number of referrals to UK adjudicators and to TEXA. But I think what's interesting is generally the large number of referrals that there are. And we know from some of the other questions that there are many parties to adjudications who don't actually go through the ANB route. They simply agree on an individual adjudicator between them. So these figures added to those responses, I think, show the health of the adjudication industry, the large number of referrals that are coming through the system. This is also demonstrated by the graph on this slide, which shows a steady increase in the number of adjudication referrals since the Construction Act came into force. It's an upward running trajectory, and in fact the year, what we've called year 23, which was May 2020 to April 2021, saw, according to the ANB statistics, the largest number of referrals. So adjudication continues to grow and continues to be successful in meeting a need within the industry for alternatives to court and to arbitration. This slide shows the responses that were made to questions about the value, the typical value of adjudication disputes that participants tend to see. And I think what's interesting is that there are a large number of high value disputes coming through adjudication. So it's not just about dealing with interim payment disputes during the course of the project, as was probably initially envisaged. They're also dealing with much higher value disputes. You can see from the slide that 2% of people have seen disputes of more than £50 million. So really, this shows, I think, that adjudication is perceived by users to be more than capable of dealing with a very large range of disputes, including very high value disputes as well. Now, moving on to the next slide about timescales, I found this particular response to questions very interesting. As you know, at the outset of the scheme, it was envisaged that most adjudications would be dealt with within the statutory scheme provision of 28 days, although of course there's some scope for that to be increased on agreement. And what figure 14 on this slide shows is that actually 28 days is the exception rather than the rule, albeit it's still the default. And really a very considerable number of adjudications are taking a lot longer than the 28 days. And that this suggests that there is quite a large degree of flexibility within the adjudication scheme and the way that it's been set up, that it enables so many different disputes to be expanded to reflect the complexity of the case and other factors that are set out in the second graph on this slide. And what the second graph shows is that the complexity of the case really is the main driver in the length of time it takes to resolve an adjudication. And I think this does suggest that the efficiency of the system in allowing the flexibility that's needed to deal with the sorts of disputes that are coming through. Now, this slide here looks at the answers that were given to the question about what was perceived to be the cause of the dispute. Now, these sorts of questions are often asked in studies of this nature, and they're, of course, by their nature, very subjective. You could have two parties to the same dispute categorising the cause of the dispute in completely different ways, and that's, of course, probably why it's ended up in a dispute resolution process. But it does nevertheless give us, I think, a really interesting insight into what is perceived to be driving disputes in the industry. And we've really got four quite clear leaders that stand out from the other causes. First of all, inadequate contract administration. Second, client changes. Third, exaggerated claims. And fourth, lack of competence of project participants. So these four causes stand out amongst all the others quite considerably. Interestingly, that was picked up by Lord Justice Coulson in his foreword on the study report, and he suggested that perhaps this shows that the construction industry has got some further learning to do in terms of project administration. And I think those figures certainly suggest that, although of course there's also all sorts of other factors behind these figures, but certainly an interesting one for further consideration. In terms of the types of claim that are coming forward, the perception of those responding to this survey is that really the largest by some margin is extensions of time, followed by final account, and only third interim payments. And as we've talked about already, the point of the scheme was really to enable cash flow through the system, and it was envisaged that most disputes would concern interim payments. But as we can see, adjudication is being used for a much wider range of types of dispute, and I found it interesting to see how highly extension of time scored. Another interesting point I think about this slide is how low professional liability scored at only 5%. I find that interesting because a lot of the adjudications that I see, both as counsel and also as an adjudicator, do involve some element of professional negligence. And that's something which, of course, at the outset wasn't thought to be one of the types of dispute that would be referred to adjudication. But my experience has been that a lot of these types of professional negligence disputes are coming to adjudication. And interestingly, the Professional Negligence Bar Association tried to set up its own separate scheme specifically aimed at professional negligence disputes and beyond construction, including other professions, because it was perceived that adjudication was successful in dealing even with those types of disputes which are generally thought to be more complex and to involve quite serious allegations. But it's interesting to see that the perception of those responding to this survey is that doesn't really make up a huge amount of the disputes that they are seeing. Moving on then to the perceptions of the fairness and effectiveness of the adjudication system, I think many will be encouraged to see that users seem to generally feel that adjudicators are doing a good job at ensuring procedural fairness. We can see in this slide that 16% say that adjudicators always ensure the parties are on an equal footing, and 62% say they do that most of the time. So a 78% figure is, I think, a very healthy one, and gives quite a lot of confidence in the system. Interesting to see how that fits with later discussion that Claire will lead about the perception of bias on the part of adjudicators, because certainly this slide suggests that any perception of bias may not necessarily be making itself felt in the way that the procedure is run by the adjudicator, at least. This slide looks at the perception of abusive process by parties to the adjudication. And what it suggests is that those responding feel that the other side are always, or most of the time, or sometimes using the adjudication procedure for tactical advantage in a perhaps abusive way in almost 3/4 of cases. Of course, one person's abusive process is another person's clever tactical manoeuvre. So I think it's of course important to look at these as very subjective responses. But certainly adjudication does give a lot of scope for tactical manoeuvring and scope for abuse of the process as well. And that's certainly, I think, reflected in the responses here. So moving on then to the next slide. So this is looking at the steps that adjudicators typically take to ensure the efficiency of the process, in particular the cost efficiency of the process. And of course, that's the whole point of adjudication, is to provide a more speedy and cost efficient means of resolving disputes within the construction industry. This is another response that Lord Justice Coulson picked up on in his foreword to the report. He said he was very encouraged to see the creativity of adjudicators in finding ways to make the process more cost effective. And this certainly does show that there's a range of different tools, many of which would not necessarily be so available or so easy to use in a litigation setting, for example. So to give one, the most important and the highest scoring of these examples, deciding the case only on a documents only basis, which is seen by participants in about 65% of cases. That's, of course, not something which a court procedure could replicate, and it would be very rare for an arbitration procedure to do that. But this is one of the main ways in which adjudication can provide a much more cost-effective way of dealing with disputes. And there's other examples that are given there which I think show really the flexibility again of the procedure, and do give some sense that adjudication is being used in a successful and effective way. Turning on then to the next slide, which is really looking at the different ways in which adjudicators deal with the apportionment of their own fees and expenses. The slide is headed cost awards, but what it means is the adjudicator's costs, their own fees and expenses. And I found this interesting because what you can see from this is that the amount of red, which shows the extent to which fees are being apportioned between the parties. And that's one of the top options that participants are saying is the most frequent way of dealing with the adjudicator's fees and expenses. And I found it interesting to see that that a 50-50 equal split between the parties is only used most frequent, the third most frequent by 50% of users. Another interesting point about this is which the apportionment of fees and expenses reflects offers to settle that have been rejected. And it seems that my perception is that this is something which has more recently become apparent. I don't think this was something which we saw when adjudication first came on the scene. And it's very interesting to see adjudicators taking the lead from the success of Part 36 offers in the litigation context to try to achieve the same sort of fairness and parity in adjudication. So that brings me to the end of my slides for just now. So I'm going to hand back to Claire.
Thanks very much, Lynn. So looking at the fairness of the procedure generally again, complaints about adjudicators reveals quite a small number of complaints compared to the small out of the referrals. RICS has the most referrals, as Lynn has already said, 1,295 referrals from 2020 to 2021, and then 1,169 the year after that. And logically, you would think therefore has the most complaints at 2.5% and 3.2% of that. The results, those complaints, no adjudicators have been removed from any of the panels who were asked the question. And some smaller A&Bs had no complaints at all. Now, given the statistics on the fairness of procedures, etc., that might reflect happiness generally. But there are some findings that we'll come on to later, which perhaps suggest that something blocking maybe people making formal complaints about adjudicators to the A&Bs. So in terms of reasons for complaints, as you can see, the most common one was lack of jurisdiction, which is obviously another reason to resist enforcement. Conflict of interest and ethical are also fairly high. Fees is at 18%, competency is lower, and evidence is lower again. So a wide range of reasons. So in terms of disclosure and bias, which I think there's been a fair amount of commentary on already in relation to this report, the question was asked about the frequency of adjudicators voluntarily disclosing information or facts or circumstances that might give rise to an appearance of bias in the eyes of the parties. Now here we're talking about the appearance of bias, we're not talking about actual bias. So it's all about how the adjudicator's behaviour and their appointment is perceived, but in the eyes of the parties, it's very subjective. But in terms of the frequency in which information was disclosed to the parties, and there may be stuff that's going on behind the scenes with the A&Bs before the appointments, obviously, that is very rare indeed. I think it's 31% of respondents said it was rarely ever happens. And then that raises an obvious question: is that rarely because there aren't very often issues with bias, which is what I think makes the next slide very interesting. This question was: have you ever suspected that an adjudicator was biased towards one party in cases that you were involved with? And the answer is 40% of people said yes, which is obviously very high. As a percentage, and not something that you'd want to be seeing. Now, there has been a lot of commentary on the phrasing of this question, because it does imply you're looking at all adjudications you've ever done. So have you ever suspected, maybe during a 20-year career, that an adjudicator is biased during that period? And I think next year there will be a narrower question just focused on the last year, and that may throw up arguably different statistics, and I think there are different views on whether it will or it won't. But it is picked up on by Lord Justice Coulson in the foreword, and this is, I've put his quote there: "This is a truly startling message, and it is to be hoped that the comprehensive and authoritative nature of this report will mean that it is promptly and fully addressed." So why was bias suspected? And by far the highest percentage, I'm just going to read it here, 63%, was the adjudicator's relationship with the parties or the parties' representatives. Now that's an interesting one, because adjudicators obviously sometimes are subject to repeat appointments, and there have been some case law in the past on at what point do repeat appointments and your fee income reach such a level that there is an apparent bias there that perhaps you may wish to disclose. The Coughley versus Bingham and Knowles case was an arbitration case, but 25% of that individual's fee income over the last 3 years had come from 25 appointments from the firm that had appointed him in this case. That was held to be apparent bias. And you would hope that if that sort of level of fee income was coming from one party or one party's representatives repeatedly, an adjudicator would start thinking that they needed to disclose this. But there isn't really a standardised code on this, and this is something that the report suggests might be a good idea going forwards. Obviously, in arbitration, we have the IBA guidelines on conflicts of interest in arbitration. Do we need something similar, perhaps regulating across all the AMBs and all of adjudication, so that parties know that if something is happening in the background, that will be disclosed to them, or that it's being weeded out in advance of the appointment, and can have a lot of confidence in the process, because 63% is a high percentage when married with the 40%. And as Lord Coulson has pointed out, it does suggest that something needs to be done to make sure that there's confidence in the process, which is absolutely key. I would also note perhaps that this may suggest a reluctance for party representatives to make complaints to AMBs. I think that's perhaps a personal or subjective opinion based on the data, but a lot of people are reluctant to make complaints in case the same adjudicator comes up with another client in another matter. So it's just something to be aware of. In terms of resignation, there's obviously no visibility here as to whether challenges were justified, but in terms of the frequency of adjudicators stepping down of their own initiative, or if they've been challenged on a conflict of interest, then that's fairly rare. 36% said rarely, 15% said never, 4% said always. So it suggests generally low resignation rates and a reluctance to turn down an appointment, perhaps. So moving on to errors in adjudicators' decisions. Now the first slide is focused on clear errors where there's a clerical, it's not clerical or typographical, so it's not the slip rule. This is obviously, again, it's perception, it's not actual errors, it's perception of errors in the decision that affect the outcome. And I should say that it's also unclear, I don't think, if anybody is aware of any statistics, I'm not aware of any on arbitration or litigation, whether that would be different, and it may also be flushed out when you see the drafts or the quality control processes that are in place for that. So that's, again, slightly different. But it's not 38% in 1 to 10% cases is not that high, but it is still, you can see in 11 to 30% of cases, 27 people said this happens quite a lot. So again, it's a quality control process. Is there something going on there? In terms of the slip rule, most of them are spotted by the parties, and I personally don't think that's particularly surprising. It's very hard to spot your own slips, in my experience. But in terms of how the slip rule is working, it seems to be working well in practice, in that in most cases, but not always, if somebody has spotted an error and they've or a slip and they've pointed this out, it is being corrected. That seems to be working well. So then another question that the report asked about was views on publications of decisions. Now, some jurisdictions have statutory adjudication and do publish decisions. So Singapore adjudication decisions are published, but with redactions to ensure confidentiality. And apparently in Queensland, Australia, they're just published without redactions. So the question here is, what do parties think about that? Now, 58% disagree, but 30% interestingly agree, but with having parts of the decisions redacted, because obviously adjudication is generally confidential unless until it goes to enforcement. And I think parties value that. So there does seem to be a large percentage of people who do think it might be a good idea, and I think that might also be something that's explored further in the future, perhaps as an idea for raising quality of decision making generally, because if your decisions are going to be on public show, then obviously you're going to make sure that they are good ones. So the other thing that this report did is look back at TCC cases and work out what was referred to litigation or arbitration afterwards. And based on this, it looks as if there's a small percentage of claims that are getting litigated or arbitrated after a decision is made. So adjudication is very often the final dispute resolution process. That's good, obviously, because that's the aim of adjudication is to resolve disputes, and it suggests that it is a powerful tool to permanently resolve disputes. That obviously has its own implications in terms of you want to make sure that the decision making in adjudication is as good as possible, because parties very often are stuck with it. So in terms of challenging enforcement, the report went back over the old High Court sort of TCC cases and looked at grounds for resisting enforcement. So this involved a bit of a trawl of the cases. Figure 40 here looks at the alleged grounds for resisting enforcement of adjudicators' decisions in Part 7 applications, and that's since 2011. And by far the sort of biggest reason is jurisdiction. Natural justice on its own is relatively low, actually, although both jurisdiction and natural justice, which often in my experience come in hand, is sort of 39. So the report analysed 189 summary enforcement cases. So it's useful to have a picture of what sort of challenges generally succeed. So generally, challenges based on jurisdiction are overall more successful than those based on natural jurisdiction and natural justice alone. So that's something to bear in mind. And again, the overwhelmingly cases, decisions are enforced. In 79% of cases, the adjudication decisions referred to this process were enforced. Only 21 cases were not, but equally, it's not a rubber stamping process. Not everything gets through. So, a healthy percentage doesn't. So there is a real process for challenging something on jurisdiction, natural justice, if there's a real reason there for resisting enforcement. So moving on to one of the statistics that I think generated perhaps the most concern or shock, perhaps, out of all of the ones in the report, and that's diversity in adjudication. 8 AMBs list their panels online, and these statistics, as I understand it from Alexander, are taken from those lists. And that is because I think some of them didn't get back in time to provide these statistics, or don't necessarily look at them. Of all the AMBs listed online, just 7.88% of adjudicators on average were women, which is obviously very low. One AMB does not have a single woman on their list at all, the ICE, although they are by all attempting to get some women, or should have a woman apparently on by next year. And this is just some of the commentary that came out in the report. There is no clear path to becoming an adjudicator, especially for non-legally qualified. There doesn't appear to be a positive drive to ensure diverse practitioners are making their way through. I have, for example, never come across a female adjudicator on an adjudication which I have been involved in. And I should add that there are no other statistics of protected characteristics that are kept by any of the A&Bs that we are aware of. So the only measure of diversity was based essentially on names and female male split. So the report then looked at some of the obstacles to underrepresented groups and people with protected characteristics becoming adjudicators. Top of the list, just go through the top three, is unconscious bias, which I know has been looked at in arbitrations as well, and that's wanting essentially a sort of a decision maker of a certain type. Poor opaque hiring or selection process was given as another top reason, and another theme that emerges in commentary and also when you're talking to people about why perhaps there aren't more female adjudicators is the lack of vacancies or capped panel numbers. So people who've been on the panels for a long time, the panel's still full, and accordingly people can't, maybe younger practitioners or female practitioners or general protected characteristics can't get onto the panels because they're already sort of full to capacity. So there was then a sort of look at what generally are the A&Bs trying to do about this. Some are incorporating diversity into their internal policies or practices. They're certainly publicly communicating support for diversity, and I know Rick's has now got a new person appointed, sort of trying to encourage that. Adjusting recruitment of registered adjudicators to account for diversity, 3 of them said that they were doing this out of 5. And there is also mentoring for underrepresented groups done by some of them. And I know some well-known adjudicators are very good at mentoring new people coming up through the chain. But I think in terms of the belief underlying that, do you believe that MBs consider diversity when making adjudicated appointments? There's 37% said no. There seems to be a general sort of lack of impetus to try and change things. And the 7.88%, I think I looked at these statistics about 3 or 4 years ago, and they were basically the same. So the report goes on to suggest that active steps are taken to try and improve the 7.88%. In line with arbitration, which has had an incredibly successful increase in terms of female arbitrators being appointed in recent years, and suggests an equal representation adjudication pledge and a task force on diversity. And the Adjudication Society is aiming to take up this mantle and will be suggesting and launching various initiatives on this very shortly. So it's definitely a space to watch. Hopefully we can improve this statistic in the next few years. So with that, I'm going to hand back to Lynne.
Thanks very much, Claire. Just finally, I'm going to deal with an interesting question that was asked in the survey. Participants were asked whether there were any reforms to the Construction Act that they would like to see. This question did require a bit more work from the participants because they had to obviously fill in some text in a box rather than simply clicking on multiple choice options. But one of the connected questions showed that 65% of respondents thought that there should be some change to the Construction Act, which is a really, I think, very high proportion of those responding. In terms of the suggestions that were made for change, the highest, the most common change that was suggested was the removal of some of the exclusions in the definition of construction operations. In particular, section 105(2) of the Construction Act, which has an exception for energy-related construction operations. I wasn't surprised to see that change coming up so high because it's certainly been the subject of a lot of cases in the TCC. I was involved in one a few years ago where the case was called Engie Fabricom versus MW High-Tech, and my client was had launched a number of successful adjudications, in respect of works to build what we said was a waste disposal facility. The other side, MW, said no, it's not waste disposal, it's an energy from waste facility. It's generating energy from that waste, therefore it falls within the exception. And the High Court agreed with MW that it was excluded by the Act. But the frustrating thing from my client there was that actually there's very little, if any, energy generated from waste in these sorts of plants at the moment. The technology hasn't quite gone so far as to make these a big provider of energy. So that was one example where that exclusion did operate in a way which certainly my client felt was difficult because it prevented it from adjudicating its disputes. And there's other examples as well where those who operate within the energy industry want to have the facility to use adjudication. And the exceptions that are in the Construction Act are really a reflection of lobbying that was carried out by particular groups in the mid-90s when the bill that became the Construction Act was first in use. So it's interesting that that's been raised, and of course that would involve some consultation to be carried out. But I think interesting for the government if or when it does come to look again at different provisions in the Construction Act, to have this source of information about what some within the industry have flagged up. The second highest response was the removal of the residential occupier exclusion. And the reasons that were given for that were interesting. This was driven, it seems in some respects, by those who provide claims consultancy services. And what they were saying is that on the consumer side, they were having to turn away a lot of prospective clients who were keen as residential homeowners to use the adjudication facility in order to bring to task builders who they thought had not done a good job or were overcharging them. But equally, some of the claims consultants were saying that they're also being approached by small building companies who had wanted to use adjudication to enforce fee claims that had not been paid. So there seems to be some appetite within the industry, at least from the point of view of claims consultants, to change that particular exclusion. Another suggestion that was made by a number of the respondents was that there should be some amendment to the payment regime to try to stop the sort of smash and grab adjudications that we've been seeing a lot of since the 2011 reforms to the Construction Act. And there was quite a lot of comment that the payment regime has become too complex. Certainly there have been several attempts to try to reform the payment regime, the 2011 reforms being the most recent of them. But it does seem that parties do to find a way to use the payment regime to tactical advantage. And I would expect that may continue. And I think what's difficult is to try to change the payment regime without just making it more and more complex, which seems to have been the result of some of the more recent reforms. So I think that was a really interesting question that was asked, and there are some suggestions that could be expanded in future versions of the survey to enable people to give their views about what could be improved, and to give government and those who are looking at reform some source of information about what changes could be made. So on that, I'm going to hand back to Claire and Jeremy, and I think we're going to see if there's any questions that have come through for us.
Okay, thank you, Claire. Thank you, Lynn, for that very thorough, very clear explanation of some of the findings of the survey. And also, actually, thanks to King's College London for giving us permission to use the graphics, which I think helped bring some of the comments and statistics to light. There have been a number of questions and perhaps also comment about some of the issues that you might not be too surprised about the two issues which have generated the most comment, but taking them in time as you discuss them, are the findings about bias really an issue? I don't know who wants to take that.
I think it often depends who you ask and their impression of the survey. I mean, obviously, I think the question on bias needs to be revamped, and it needs to be limited to the last period, the last year after we've had this one. So next year, in the last year, have you ever thought there was apparent bias? And I think until we get that statistic, there will continue to be arguments either way. I think 40%, even over the last a large number of years, is still it's very significant, and I think something needs to be done about it. I mean, Lord Justice Colston obviously thinks that was based on his forward as well, and he is not one to be dismissed easily. And I think in terms of getting confidence into the process, having some sort of guidelines that's out there and is universal seems to be a very easy thing to do comparatively. That could be quite a good way of making sure that you know, if somebody is getting a lot of their fee income from one place or one client or something, and that's beginning to have a feeling, you know, too much familiarity, even if it doesn't have an impact on the decision, it's really important to imbue confidence, and I think that could be done fairly quickly and easily.
Okay.
Yeah,
Lynne?
I agree with that. Yeah, I think it's, I mean, particularly given how much publicity the survey has had, and this particular aspect of the survey has had, I do think it's a matter of concern. I think it's something that within the industry we have to do to address it, if even if only just to show that we have taken this on board and that steps are being made to make it a more level playing field. I think Claire's suggestion, which I know is being given quite a lot of thought in some quarters, of some kind of code of practice or guidelines, is a really good one, because at the moment all we really have is the case that Claire mentioned, the Coughley case, and actually, you know, you can't really just rely upon the case-by-case development of this within the courts to give you a comprehensive code for this. It's something that I think has to be discussed within the industry and consultation made, and then produce something which people can have bought into and feel comfortable with. And it's a relatively straightforward step to take, and one which I think could give a lot more confidence in the system, and also help adjudicators themselves to know when they're at a point when they need to declare something or be transparent about something.
Yeah, no, I mean, I think that's important, and I know that TEXA, when you get the invitation to sort of say whether you're available to carry out an adjudication, that you get an email that asks you to think about things, including questions of bias. So I think there's some kind of more formalised position that might assist. Adjudicators have to take the lead themselves, I think, and transparency is very important. And something that's linked to both bias and the other issues I'll come to. How representative is the survey of adjudication used in this thing?
Yeah, so that's something, of course, which people have been questioning, saying, you know, do we have is there a certain type of person responding? Is there enough representation from different parts of the industry? I felt that the slides that we showed at the start of the talk did show that there was a good representation of different types of users of adjudication in those responding, and a 257 response from individuals is a high number. But I think we can be quite confident there is good representation from the fact that 10 of the most important and most commonly used adjudicator nominating bodies have provided their data, because although there's a lot of people go outside the ANB to agree an adjudicator, there's still a huge number of parties that go down the ANB route when appointing an adjudicator and referring a dispute. So I think that can give us a lot of confidence in the figures, and can give us the sense that actually there is, you know, a lot of reliability in the experience and perceptions that are being reflected in the answers.
Okay, thank you. I
think also hopefully the well-known nature of this report will encourage more responses, even more responses next year. But I think this report has more responses than any other report that's been done previously, so that's a good starting point.
Yeah, and it becomes regular, so people more likely to respond. You've obviously talked about questions in relation to lack of representation and lack of diversity amongst adjudicators. What do you think the barriers are to more female construction practitioners actually acting as adjudicators? What can be done?
So this is a really interesting question, and when you look at the individual ANBs and the numbers of women on their panels, I think TEXA and TECBAR fare pretty well compared to some of the others, because there are a lot of senior women at that stage who are putting themselves forward as adjudicators. I think really the difficulty is within the quantity surveying industry, and you see what a large proportion of the disputes relate to QS payment, final payment and interim payment disputes. And so it feels to me like this is a flag that's been raised that more needs to be done within certain sectors of the industry to encourage women to put themselves forward. I mean, we all know that there are female quantity surveyors, of course, but what is being done to encourage them to come forward? Are they at a senior enough position to feel comfortable to put themselves forward? But one of the things I think is really important to emphasise is, so I was Secretary of TECBAR for many years, and one of the things we did was try to increase the number of young people who were putting themselves forward to qualify as TECBAR accredited adjudicators. Because what we were finding was that often the referrals that were being made to us were for relatively low value disputes, and they wanted a more cost effective adjudicator. They were looking for somebody who was more junior, and there was a perception within TECBAR that you had to be a silk to put yourself forward to be an adjudicator, and that was something that we worked very hard to address and to say, no, we want people from all levels of seniority. And that drive, we had a recruitment drive and we set up more training, and that did bring forward a lot of younger people, and it automatically then brought forward a more diverse group of people, because of course the nature of our industries is that there are more diverse groups of people applying and coming forward in the junior section than traditionally there was. So that could be a way of encouraging quantity surveyors to put themselves forward, to make it clear that you can bring that expertise at an earlier stage of your career than some people might otherwise have thought. So definitely a food for thought.
So I think one of the things that people have said in conversation is that you can do all the training and then try and do the mentoring if you can get a good mentor, and there are a couple of very well-known adjudicators who do a lot on that. But then getting onto the panels is still incredibly difficult. It sort of becomes a chicken and egg situation. So I think something needs to be done with that, because obviously we need to bring through talent in the decision making, or you'll get a gap in terms of experience, which won't be filled quickly.
Yeah, I mean, and sort of steps need to be taken, because perhaps the most depressing thing that you said, Claire, was that you looked into the percentages 4 years ago and nothing had really changed. And
yeah, I did a blog on it actually about 4 years ago, and because I was really interested in the ICC report that said what they'd done and how they really made a big difference very quickly. And unfortunately, yeah, the same thing hasn't happened yet in adjudication, but hopefully it will soon.
Well, I mean, there's an opportunity to use the findings of the report to start moving things forward, hopefully. But we shall see. And just finally, how would have you answered the final question? What do you think the government should be considering, if anything, in relation to reforming the Housing Grants Act?
Well, I think I probably gave myself away. I said the same as the top answer about changing the exclusions, but that probably reflects my own experience with the case that I mentioned, the Fabricom versus MW case. Who knows, I may find myself on the other side of that dispute in another case and have a completely different view. But I do think, on a more serious note, I do think that what the survey shows is how successful adjudication has been. It's it's developed beyond the remit that it was initially given to encompass a much wider range of disputes, values of disputes, and it's a very flexible and cost-effective way of resolving disputes. And we all know that it's getting more and more expensive to resolve disputes in court and in arbitration. And it does seem to me that it's to all those involved in the energy industry to have that same kind of facility available to them. And there are lots of expansions of adjudication. I mentioned the Professional Negligence Bar Association scheme, but the Society of Computers in Law have also set up their own adjudication scheme. Adjudication is now being brought to Ireland. Other countries are looking at it as well as a model. And so my view is that it has been so successful, and it does generally get the buy-in of those participating in it, as the figures show the small number of cases that go on to court. And as it becomes more expensive to deal with things, I think it is helpful for there to be more options for different industries available to them. So that would be the change I would advocate for.
I'm suffering from a rush of smash and grabs at the moment, and I think there is something about that. People find the payment mechanisms difficult in terms of hitting the deadlines and calculating them, etc. And I think if somebody can work out how to simplify that, that would be a really good thing. The question is if they can work out how to do it. But yeah, people do seem to find the calculations difficult, and that is breeding problems, I think.
Okay, thank you. I mean, for myself, I would actually be wary of amending to include the residential occupier exclusion. I just think the nature of the parties to the contract might make that quite difficult in a number of instances. But Lynne, Claire, thank you once again for your discussion and your comments and your questions, which have been absolutely fascinating, and hopefully generate more thought and discussion, and hopefully positive developments in the development of education over to as 2023 goes on. And everyone listening, please remember, when you hear details of the next survey, fill it in, because your views really do count, and they will help shape adjudication as we move forward through this year and beyond. Thank you, Claire. Thank you, Lynne. It's just time for me to say that we'll give you details of our next webinar, taking place on Thursday, the 23rd of February, where my colleagues Simon Tolson and Karen Gidwani will be joined by Sanjay Patel from Court, and they'll be looking at termination, the latest legal contractual developments, focusing particularly on the recent Energy Works Hull case, which came out just before Christmas. So thank you all for attending, and hopefully see you all again in February.
Thank you very much.